All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Welcome back, everyone. We will now continue with the submissions, but for tomorrow, just some housekeeping matters. I indicated earlier that tomorrow, for purposes of the closing or roundup remarks, time has been added. So let's announce that for now and see how whether we need more time. We hope to finish by lunch break tomorrow. We, for now, will say Jordan would have 60 minutes of roundup time tomorrow. So does the prosecution, and the AU would have 40 minutes, and the legal scholars would have 25 minutes each for roundup remarks. And we hope we can say all that needs to be said, say that advisedly, within all that time, and we'll see whether we'll need to extend any time if we need to. Yes, Ambassador.
Your Honor, thank you. Is it going to be the same sequence that's described in your earlier circular? Thank you.
The only thing that changes is the time, but sequence remains. Thank you. Now we will. It's your turn, prosecutor, to respond, right? Yes, please.
Thank you very much, and thank you for the time before the break as well. Your Honours, I think we'll just use these 5 minutes to make what I hope will be 3 quick points. First, I think, Your Honour Jajibo Suji, I'd like to try to address your question regarding the South Africa situation. Of course, when I was speaking earlier, and thank you, Mr. Clady, but I was referring to the South Africa decision, the findings in that decision at paragraph 136. But of course, we are aware that other things happened. Now, if the question is, if South Africa's actions towards withdrawal affects its non-referral in that sense, then I think we would see it as 2 separate questions. Now, it's one thing what a state does when it's within the fold of the Rome Statute, when it's a state party, and there's a duty to fully cooperate and under Article 86 and everything else in Part 9. And so it's assessed on that basis. But we see it as a somewhat separate question on a state exercising what perhaps is a sovereign right to withdraw from a treaty. Now, it's unfortunate, but
that's not the. Maybe we misunderstand each other. The orientation of the question, my question is this: in the decision, and Jordan is asking on what basis would South Africa be given all the reprieve and not there? And the reprieve we're talking about, a number of things, considerations taken into account by the pretrial chamber. And that included that South Africa indicated they were in a mode of cooperating more, something to that effect. And Mr. Gladly saying, well, not quite so, because South Africa was not in the mode of cooperating as much as indicated in the pretrial chamber decision. And the question then becomes this: all right, if South Africa was not in the cooperating mood to the extent of indicating withdrawal, is it then fair to Jordan, who did not act in that way, advert to them to not receive the same kind of reprieve that South Africa received.
Yeah. Yes, Your Honours. And I think I was trying to come to that. Now, we don't see the question of South Africa's non-referral and its subsequent actions as being anything particularly connected to Jordan's referral. And we've said that quite a few times, and I believe the
But
same
there was
line
distinguishment made.
I'm sorry?
There was a distinguishment, some exercise in distinguishment was made in the pre-trial chamber decision,
Well,
differentiating why South Africa wasn't referred, but Jordan is referred.
I think Your Honours is referring to paragraph 54. Now, of course, Your Honours, perhaps that paragraph could have been written somewhat differently, but we don't get any other sense from that paragraph except that they were talking about a position of law, Your Honours. We're talking about the fact that a state party cannot suspend its obligations unilaterally and that consultations do not have that effect. And of course, we've addressed that point earlier, so I won't do that. We don't particularly see any factual comparison between South Africa and Jordan. And even if, and this we would not concede really, but even if somebody was to see it that way, there are plenty of other factors in the decision which we've been through already, which reflect the pretrial chamber's thinking about why they think perhaps Jordan should be referred. And I think this would be a good time to emphasize, Your Honours, that the referral has many purposes, and the referral in this case was value neutral. We can see that quite clearly from the last paragraph as well as the previous analysis, where they essentially say, well, the court is a judicial body. This is what we've done.
And then it returns to the question, doesn't it? That value neutrality, why didn't it apply to South Africa?
Well, but Your Honours, that's for the purpose of the South Africa decision, which, as I understand, is not under appeal here. Now, that's a different question altogether, I think, about the South Africa decision.
It's not under appeal as such, as much as that it was referred to in the pre-trial chamber decision, contrasting that situation.
Yes.
The pre-trial chamber decision in relation to Jordan. South Africa was referred to.
Yes.
And Jordan has said that distinction ought not have been made. It has always been their contention.
And I think if I wasn't clear before, I think we were saying that that distinction on a factual basis was not made. If at all they referred to South Africa, it was only in the context of the legal principles, which are anyway universal. It's got nothing to do with South Africa's non-referral or referral or Jordan's referral. So that's how we read that. And Your Honours, while we're talking about referrals and value neutrality, perhaps this is a good point for me to address Mr. Robinson's helpful suggestions. We wanted to do it previously, but perhaps this is a good time. Now, Your Honours, about the concept of exercising restraint about a referral, we don't actually see why that should be an issue, given that the pretrial chamber saw this referral as something that would advance cooperation. And for this, I think I must refer to Mr. Kress's very helpful chapter in, of course, the famous commentary Trifter, where he makes the point that the state's failure to cooperate, and it's at the non-compliance level that obligations are incurred for the purposes of 87. So in that sense, the referral is not really connected to incurring obligations. And of course, I wouldn't want to speak for him anymore. Now, so we really don't see the concept of restraint as necessarily holding back a referral that would advance cooperation in all the many ways that the ASP and the Security Council can do. But then this perhaps brings me to the point of the conference, high conference, intergovernmental conference exception. And it may tie in perhaps to your question earlier about that. Now, we did listen with a lot of interest at the very thoughtful submissions of Mr. Robinson on the need perhaps to introduce such an exception. But what is clear to us is that proposal can't apply to the facts of this case. Jordan has never really relied on such a policy, and as you see, the note verbals speak about grounds of law, customary international law, Article 98, all the discussion that we've had. And also, I think, if I recall the discussions yesterday from both Jordan and the League of Arab States, there seems to be consensus, perhaps unusually, that the referral of non-compliance should be addressed to the facts of this case. But still, considering that suggestion...
You're out of time.
Oh, shall I address it later?
Yes, you may.
Yeah.
Because there will be question time.
Sure.
And then
Absolutely.
you may return to it at that time. But let's stick to our timetable for now.
Yeah.
Thank you very much. Now, Jordan.
Thank you, Mr. President. Just a few comments in response to what we've heard. First of all, the OTP, the Office of the Prosecutor, says that it never claimed Jordan's arguments were valid in the process that occurred in March of 2017. That's certainly true, but we don't think that's the relevant issue. The relevant issue is the prosecution itself said Jordan has approached the court, Jordan is seeking consultations, Jordan has a legal approach. We need to clarify that. We need to get back to Jordan. They said that on March 24th. They said that after the March 28th note, and the pretrial chamber did nothing at all. That's the core issue that I think needs to be kept in mind. If there's a question about did Jordan do it properly, the consultations properly, did we ask a question? Was there some specific magic buzzwords we were supposed to use? The answer is no, that the Rome statute doesn't say that.
Isn't that the issue about immunity now? Whether we have to use specific buzzwords to say effect of something.
And Jordan said in its note verbal that it believed that President al-Bashir had immunity, and that that immunity is something it must abide by under its obligations under international law. So we directly raised the issue. We were looking for a response. If there was something more we were supposed to do, it'd be interesting to hear what that is. We did put in your judge's folder as the last item the December 2017 ASP, Assembly of States Parties resolution that tries to clarify the consultation process. There too, no magic words, asking questions, whatever, need to be a part of this request for consultations. But what is quite clear in paragraph 4 of the resolution is the obligation upon the court, upon the OTP, to get back without undue delay once the request for consultation comes in, and that was never done. The Office of the Prosecutor says that this isn't an issue of automatic referral. The pretrial chamber must just apply its mind to these circumstances. We submit 4 sentences of analysis is not applying its mind to the facts that were at issue with respect to Jordan. If you look at the South African referral, it's pages and pages of discussion weighing back and forth whether a referral was appropriate. In our case, it's 4 sentences that are extremely parsimonious. The only thing that stood in Jordan's way was its own decision, says the prosecution. Well, if the issue is, could we have physically arrested a person in Jordanian territory, it's true. Jordan decided not to do that. But the way that the consultation provisions are written in Article 97 is to clearly anticipate that if there's a legal impediment, it's proper to pursue consultations. And in subparagraph C, it talks about that in the context of conflict with treaties, but it's an inter alia, among other things, a conflict with treaties. It's not exhausting the possibility of legal impediments. Jordan did have a legal impediment both under treaties and under customary international law. Prosecution says we waited to respond 5 days before the visit. Well, we were waiting for some reaction from Sudan as to whether the president was actually coming. This was an important issue. And once the visit became a real likelihood, we did approach the court. We did explain the situation. These were complicated legal issues. Look around us this week, how many people are here trying to sort these things through. It was not easy, and I would submit The court itself, if there was some urgency here, waiting too close to the visit, never came back to Jordan at all. It was Jordan that initiated the response. Most importantly, perhaps, many of these issues, all of these issues really, the delay in getting back to the court, the failure to ask a question of the court, none of this is in the pretrial chamber's decision. So if this is the reason for the referral, the chamber should have said as much, and at the end of the day, they didn't. Now, the issue of there being a lot of different legal theories and the idea of all roads leading to Rome is a nice concept, but the reality is the road identified in mid-March, ultimately the decision was that doesn't lead to Rome. Ultimately, the pretrial chamber says this implicit waiver theory from the Security Council is wrong. Well, if it's wrong, then Jordan's position in mid-March was correct. And it may be, based on whatever decision you reach, you'll say, we think you didn't have it right. Fair enough, but as of mid-March, Jordan identified correctly that a particular theory was wrong, and that meant its approach may well have been right. The prosecution says we haven't discussed the value of the referral. We did. In our written pleadings, I believe in our oral pleadings, we don't think a referral would serve any purpose. President al-Bashir is not in Jordan. Jordan is fully cooperating with this court. We believe that's evidenced by the fact that we are here this week making our arguments with utmost respect to you, utmost respect to the prosecution. We don't believe that anything was crystal clear in March 2017, and we would submit that this entire proceeding bears that out. Last point. If the claim is being made here that a referral is needed for purposes of setting a long-term example for the well-being of the court, for putting Jordan out there as something that the rest of the world should take notice of, we submit that's an arbitrary approach. And we submit that at the end of the day, with all due respect, it's punitive in nature.
Thank you very much. We will now go to questions from the bench. I'll begin with a question to the OTP. And this question is asked against the backdrop of Mr. Newton's data of travels. And the question is this. Here we have all these travels going on. And what appears to put it very diplomatically, cat and mouse game happening whenever travels happen. It engages the question, at least for purposes of whether a state party who has not complied with a request to arrest and surrender, therefore needing referral to the Security Council or the ASP, is exercise of a court's jurisdiction conditional on arrest and surrender? Such that when that doesn't happen from a state party, that state party must be referred.
Your Honour, I think that has a simple answer, and I think the answer is yes. It does, because the court can't exercise its jurisdiction, and that's fundamental.
In the in the in the joint opinion of Judges Higgins, Bugenthal, and Coimans in the arrest warrant case, they seem to suggest otherwise. Are they wrong? Saying that there are many countries in the world where accused persons can be tried without them being in the courtroom. There's case law from the European Court of Human Rights, for instance, that seems to say that yes, you can proceed and try an accused person if you've given notice, sufficient notice to make them come and defend themselves. If you do that trial and they show up later, you can repeat the trial if it is shown that they did not get proper notice. Is it conclusively out of the question in this court to proceed in that way? So that we don't do a lot of cat and mouse games with accused persons and having these kinds of proceedings.
Your Honour, I think again it's a fairly short answer. We know there are no trials in absentia at this court. That's very fundamental in the statute. It was hard fought. There were countries in the Rome negotiations who wanted to have that provision, but we didn't. That was not included. But in the end, what was included was Article 61, confirmation of the charges before trial, and that does allow an in absentia proceeding. But that's as far as it would go. So I take Your Honour's point that we could get to a certain level if that was the choice of the prosecutor, to take it to that level. But trial, no. I don't know whether my colleague, Mr. Raston, wants to say something specifically about the arrest warrant ICJ case, but he seems to be rising.
Yes, he may rise, but here's another angle to it. Is there a distinction between, when we talk about trial in absentia, in some jurisdictions, I understand it, the concept means different things. There are places where trial in absentia is when you are proceeding against somebody there's no basically linkage to jurisdiction in the first place, versus somebody who's within the jurisdiction, normatively speaking, but refuses to show up at the appointed time for trial. You may have a scenario, for instance, where a non-state party person, for some reason, the court decides to go after that person. They don't show up. You proceed. Versus a scenario where the person from non-state party is really within the jurisdiction of the court, either because they have their state. The Security Council has made a referral giving jurisdiction, versus a scenario where there's no Security Council referral, and there's also no membership in the UN, in the Rome Statute, and the court seeks to proceed against that kind of person. Do you see what I'm getting at? There are different scenarios. Does the concept of trial in absentia and reticence to it apply differently according to those different scenarios?
Just briefly on trial in absentia, then I'll come back to the question about jurisdiction. I believe, as Ms. Berry said, the current framework that we have, of course, is governed by the statute. The Security Council cannot fundamentally alter the statutory regime. We've had an amendment of the rules in terms of continuous presence at trial as a result of, you're very familiar, of course, the precedents that led to that. So that Rule 134 is there. But that doesn't say that the very start of trial can actually occur without an initial appearance. So we understand that the current regime does not allow the full absentia proceedings to continue. And then the question of whether or not, coming back to Judges Higgins, Cummings and Bergenthal's opinion, whether or not we can look at this question of jurisdiction immunity sequentially. Well, of course, in our context, because the proceedings cannot progress, at least not beyond a confirmation process, without an arrest and surrender occurring or otherwise a appearance pursuant to a summons occurring, then yes, the non-arrest or the non-surrender of persons pursuant to warrants is fundamental in allowing the proceedings to progress or not. And this then links very briefly to your comment about Article 4.2 and functions and powers, and actually the comment made by Professor O'Keefe earlier. It does fundamentally impact on the functions and powers of the court, because the observation was made earlier that if functions and powers in Article 87.7 is looked at, then it only relates to when the court is exercising functions on the state's territories, investigators or judges' personnel, and it doesn't extend to an ICC surrender process. But if that was the case, the functions and powers within Article 87.7 didn't extend to the ICC surrender process, then why are we even here in this hearing? Because this hearing is to determine whether or not there's been an act of non-compliance, and that requires a finding that the court's functions and powers have been frustrated. So the very reason that we're here in this proceedings is because the court's functions of powers have, according to the pretrial chamber, been frustrated through the non-arrest and surrender of Mr. al-Bashir. So it is fundamental to the way in which the statutory regime operates, we would argue.
The distinction was made between proceeding to trial without the person versus doing confirmation hearing without a person. Again, we come back to Jordan's scenario here. As I understand it, there has not been confirmation hearing. Would we say that Jordan's non-compliance has frustrated even the confirmation hearing to the extent that the statute allows confirmation hearing to take place without
Sorry, I would merely observe the opposite. I would say that is their obligation to arrest and surrender suspended pending a hypothetical confirmation in absentia? Their obligation is triggered by the duty that's incumbent upon them as it stands at the day in which the warrant is issued. And certainly that hypothetical scenario cannot be pleaded in excuse of not meeting their obligations.
You must say this question came out of nowhere. It's in the process of thinking about your complaints. Another question is to Dr. O'Keefe. In the interpretation of in your submissions on the part of Article 27.2, if I understand it, you were saying that 27.2 speaks to the doctrine of non-justiciability. In other words, act of state, or did I get you wrong?
No, Mr. President, you got me right, but only to a narrow extent, because what I'm trying to point out is that Article 27.2 speaks on the one hand of immunities,
yes,
available under international national law, or special rules of pleading. Now, the special rules of pleading are specifically those under national law, and indeed, the reference to special rules of pleading, in fact, in a way strengthens my case. So there are certain strictly national law doctrines, for example, in the United Kingdom and a range of other places, that there are certain exercises by the executive of the royal prerogative that may not be reviewed, certain exercises by states of sovereign powers in the realm of international affairs, the so-called Boots non-justiciability, that are also ruled out before the court. So I wasn't trying to say that only such doctrines are ruled out. I'm trying to say that that's what explains the reference to not only immunities, but special rules of pleading. And those special rules of pleading are rules of national law that are also ruled out before the court. So in other words, the court may simply brush away the plea by a head of state, an official or something like that, that in being prosecuted, you are calling upon the court to judge the exercise by the royal prerogative of the government of Her Majesty or something like that. So in other words, I'm just trying to explain the full scope of Article 27.2, which goes beyond immunities.
Yes. A lot of people have tried to make sense of Article 27.2. So what is it doing?
Right.
If you have 27.1 that says what it says, what is 27.2 doing there? And the way you've explained it, it looks like Act of State doctrine comes under 27.2. Is it possible also to look at 27.2 from the perspective of that distinction, the famous distinction we talk about in arrest warrant case between jurisdiction speaking to substantive matter and immunity speaking to procedural matter?
Right.
Again, we can look at it in the language of ratione materia versus ratione personae, which, if we use those kinds of distinctions, which one would apply to 27.2 as you see it? Again, this is for everyone
Sure,
to help us
sure.
make sense of 27.2. Some may say, let me pop it directly. Some may say that it goes more to the so-called procedural immunity or ratione personae than substantive.
Right, I get that. Okay, Mr. President, if I may, let me first clarify the second part of your question before addressing the first. Both immunity ratione personae and immunity ratione materiae are purely procedural bars. Immunity ratione materiae is no less purely procedural than immunity ratione personae. It is simply that their scope is different and that their rationale is different. If I may explain immunity ratione materiae, it remains a procedural immunity which prevents the exercise by one state of jurisdiction over the official of another state. But it bars that exercise only in relation to acts performed by that person in the exercise of, in their official capacity. Okay? But it remains a procedural bar. It is simply a narrower procedural bar than immunity ratione personae in terms of subject matter. It covers only those acts performed by the official in his or her official capacity, whereas immunity...
But once you perform that, assuming it is, we use that expression, opposable, assuming it is cognizable that if you are acting in an official capacity, you're exempt. If that is the assumption, does there ever become a time when you will be prosecuted for that thing that you did in your official capacity?
Right. Mr. President, the simple answer is no, the time will never come. The time will never come.
Is it then substantive bar and
Absolutely not.
ratione materiae?
No, Mr. President, because your state could always waive that immunity. And the fact that the state can waive the immunity proves incontrovertibly that it is purely procedural. Now, don't take it from me. Take it from the European Court of Human Rights. In the Al-Adzani case, the Kaloyeropoulou case, and every case on which it's talked about immunity ratione materiae, it stresses time and again it is a purely procedural bar. Now,
what then is the material one? What then is the substantive?
Right, so, well, this brings me to the first part of your question, and forgive me, this involves a slightly technical thing, but I hope to do it pretty quickly. The term act of state is used to refer to two separate pleas. It originally, at international law, referred to the plea raised at Nuremberg, even though it was barred by Article 7 of the Charter, the substantive plea that the official was not criminally responsible in the first place because he or she acted as the state, as it were. So act of state in that way, as used by Hans Kelsen, Lauterpacht and various people at the time, was used to refer to a substantive exemption from the law. Now that is found in Article 27(1) of the Rome Statute, which, in the same manner that Article 7 of the Nuremberg Charter did, and Article 4 of the Genocide Convention did, says that it is not a substantive defense to say that you acted as a state official. In other words, that you cannot be held criminally responsible. Unfortunately, and this is something that is constantly having to be explained to students in at least the common law world, the same language is used to refer to a completely different concept, one that is one of justiciability, which says that certain subject matters cannot be considered by the court. Now that is different, once again, from immunity ratione materiae, and let me explain the difference. Immunity ratione materiae, although applying with respect to acts performed in an official capacity, serves as a bar to proceeding against the person, him or herself. So it remains a procedural bar to the amenability of the person to the jurisdiction of the court, but in respect of certain acts. The non-justiciability doctrine of act of state bars consideration of the acts themselves, regardless of who the defendant or the accused may be. So you may be prosecuting, for example, a private official, a private individual, or indeed an official whose immunity has been waived. Let's imagine that case. An official whose immunity has been waived. Such an official would not enjoy immunity, whether ratione materiae or personae, but it is not out of the question that that official might stand before the court and say, okay, you have me rightly before the court because I enjoy no immunity, but you can't adjudicate this question because it involves examining the sovereign acts of the United Kingdom government or the sovereign acts of the United States government or something like that. Can you see the distinction? So immunity is a bar to proceeding against the person in relation to certain subject matters, or in relation, when we're talking immunity ratione personae, to all subject matters while they occupy that position. Procedural act of state prevents consideration of certain issues. Substantive act of state, Article 27(1), okay, says that you're not responsible. So substantive act of state is in Article 27(1). Procedural immunity and procedural act of state are covered by Article 27(2). I hope that rather involved and somewhat technical analysis provides assistance to the court, but I would be delighted to talk about one of my favorite topics, which bores most people.
Thank you very much. Mr. Cross.
Your Honour, if I might interject a little on this subject. We, I think, would agree that focus on what is the meaning of 27(2) is the heart of this appeal. And we welcome the fact that we are now coming to look in some detail at what is the intention and effect of Article 27(2). And we agree also that reference to terms such as the significance of national law in 27(2) may well be a very relevant consideration. Of course, from the prosecution's point of view, our primary view, as also expressed by Mr. Robinson amongst others, is that the reference to national law does indeed give the clue that 27(2) extends, among other functions it may have, to Part 9 matters, to cooperation. Mr. O'Keefe has made some valuable comments about some of the other functions that might also be read into 27.2. And I would note that 27.2 begins in the plural. It says, just to quote, immunities, plural, or special procedural rules, plural, which may attach to the official capacity, and then it goes on. Whether or not you can read the provision as only referring to one kind of immunity and special procedural rule or multiple immunities and special procedural rules is again a question of interpretation. My learned friends opposite have told us during the week that the prosecution is trying to avoid in some way an Article 31.1 interpretation of 27.2. And just to reiterate again, we are not. We welcome a 31.1 interpretation of 27.2. And in that context, we stress again that we have to combine jointly the ordinary meaning of the terms, the context, and the object and purpose. Now, we're getting into some interesting questions here about the ordinary meaning of the terms. What is the significance of the fact that immunities and special procedural rules are in the plural? What is the significance of the reference to national law? What is the significance of whether or not this will bar the effective jurisdiction of the court? Those are some of the questions that the ordinary meaning of the terms raise. How do we answer those questions? Well, we also have to look at the context, and we also have to look at the object and purpose. Now, in terms of the context, one of the key considerations is the relationship between Part 3 and between Part 9. There is a question: how is the court going to execute a request for arrest and surrender of the official of a state party? If 27.2 does not say that state parties may not raise the official capacity of their official as a bar to that request and surrender, then we are faced with a fundamental question about the way in which the court will function. To borrow Judge Cassesi's analogy, the giant isn't just, at that point, the ICC giant isn't just without arms and legs, but, Your Honours, we would submit it's on life support. How is this court going to function if that basic proposition that official capacity is no bar to your trial here in these proceedings does not also mean that official capacity is no bar to being arrested in order for those proceedings to happen? Now, again, a key question is the relationship between Parts 3 and Parts 9. My learned friends have said that Your Honours should look at Part 9 as if it were effectively a self-contained regime, and Part 3 in Article 27 as if it has nothing to do with Part 9. We would submit that's entirely inconsistent with the approach in the statute. Article 86, for example, the general obligation to cooperate. Not only does it say that states shall cooperate fully, and I'd like to come back at a suitable moment on what Article 86 might mean, but it also says in accordance with the provisions of this statute. It doesn't say just in accordance with the provisions of this part. Likewise, 87.7, another of the provisions which are at the heart of these proceedings, again refers to cooperation in accordance with the statute, not just this part. Likewise, my learned friends mention that, I believe, Article 89.1 refers, this time, to this part and not this statute. But there we think that reference can be explained by reference to the procedure in Part 9, including Article 98. But we don't think you can take from that that this is a suggestion that, again, Article 89 exists only in the context of Part 9, not least because Article 59, which is entirely relevant to those same questions about what to do when a state receives a request for arrest and surrender, refers to that part. I'm not sure if there was a question, so I was just pausing at that point if Judge Hofmansky had a question. No. Thank you. So for all these reasons, we would say when you're looking at 27.2, you have to consider, yes, the reference to those terms in the statute, but you also have to consider the context, you also have to consider the object and purpose. And there may well be some tensions. There is sometimes some balancing which has to be done in treaty interpretation. And that's exactly why 31.1 gives this tripartite test. And that's exactly the approach that we're urging Your Honours to take. I think probably that concludes my submissions. Thank you.
Thank you, Mr. President. And I'm sorry if my excitement got the better of me. I also have a confession. While you were speaking about referral, on the subject of which I don't really have a point of view, I was preparing my notes for tomorrow. My notes for tomorrow include a reproduction of the argument made at paragraphs 4 to 6
You
of
think
my
you can
written...
give it to us tomorrow?
Pardon?
You think you can wait until tomorrow?
No, it can't. It's directly on what was asked there. However, given that I have to learn self-restraint, I will first answer the question of immunities in the plural. There's diplomatic immunity, head of state immunity, head of government immunity. There's immunities, all of those, ratione personae, immunities ratione materiae. There's lots of immunities. In the same way, there's lots of procedural rules. It doesn't tell us much. I want to get to the absolute heart of what Mr. Cross has just said. And it's a point that hasn't come up yet, and it's a point that I was going to make tomorrow. A fundamental objection to the position that I take, the African Union takes, Jordan takes, might be precisely what was said a minute ago. If Article 27.2 is incapable of applying to surrender proceedings at the national level, how is it that states parties, as is uncontested, are not obliged to respect the immunities of the officials of other states' parties when surrendering the person? The answer is not Article 27.2. The answer is purely and simply the unqualified terms of the second sentence of Article 89.1. Article 89.1, the obligation of surrender, makes no exception on its face for persons who would otherwise benefit under international law from immunity from foreign criminal jurisdiction and inviolability from foreign arrest. In other words, on its face, and I'll go back to that in a minute, on its face, on its own terms, Article 89.1, the obligation of arrest and surrender in Part 9 of the statute requires a state party to arrest and surrender to the court any person the subject of a request. On its face, any person the subject of a request. There is no exception made on the face of it in relation to state officials. In consenting to the unqualified terms of Article 89.1, a state party accepts by the same token that each other state party will be obliged to arrest and surrender to the court any person of the first state party, irrespective of any immunity and inviolability from which the first party would otherwise be entitled under international law to see the person benefit. Let me put it simply. We all sit down. We all sign something which says we have to hand over people to the court. No exception made whatsoever in relation to all our officials. We're all therefore recognizing you're going to have to hand over our people at some point if asked to do so. We're going to have to hand over your people at some point if asked to do so. Well, it looks like we all agree to that. In so accepting, a state party waives to the same extent any such immunity and inviolability. Now, of course, it might be objected, as rightly it should be objected, that this waiver is not explicit. But in relation to Article 89.1, given that it is absolutely clear from the travaux préparatoires of the Rome Statute that the states involved in the drafting, which later became the states' parties, understood perfectly well and accepted that the persons to whom their obligation extended under Article 89.1 included the officials of other states whose arrest and surrender was requested by the court, I think in those circumstances, given what we know of the common understanding in the background and the uncontested acceptance that states parties are obliged to surrender each other's officials, that we can say that that waiver is sufficiently explicit. Now, on its face, therefore, Article 89.1 applies to the officials of non-states parties. On its face, you have to arrest anyone the court asks you to arrest. And that is why Article 98.1 is there. Because what Article 98.1 says is that if you owe an obligation to another state in relation to the immunity of one of that state's officials, you're exempted from the obligation to surrender the person to the court, found in Article 89.1. So let me just put it very simply for you, and Article 27.2 does not come into it at all. Article 89.1 says, hand over people to the court, just says that, unqualified. I sign it, my friend here signs it, you sign it, we all agree. We've got to hand over everyone to the court. I know that you've got to hand over my people. You know that I've got to hand over your people, okay? But this creates a problem in relation to states like Sudan. We don't want to have to hand over the head of state of Sudan. That's why we put Article 98.1 in the statute, which says we don't have to hand over the head of state of Sudan. Article 27.2 has not the slightest thing to do with it.
But
it's all to do with Article 89.1.
Does that calculation of we don't want to hand over
Sure.
the head of state of Sudan, hasn't it ignored a critical element in this case, and that is the head of state of Sudan comes into the story because of a resolution under Chapter 7 powers of the UN Charter.
Sorry, Mr.
Doesn't that make all the difference?
Sure. When I referred to the head of state of Sudan, sorry, I was just giving an example. I'm leaving aside Resolution 1593 here.
Yeah, but that is a critical,
Yeah, I know it is.
factor because it makes all the difference between 89 and 98,
Sure.
read just as they are.
Sure. What I'm trying to explain is the architecture of the statute. In principle, leaving aside the interaction with 1593. I'm just talking about, let's leave the head of state of Sudan out of it and call him or her the head of state of Ruritania. I'm just trying to explain the interrelationship of the provisions. Article 89.1 says we've got to hand over everyone, but Article 98.1 says not if they're an official of a third state, okay, in relation to whom you owe obligations. Well, we don't owe obligations to the state's parties because we've all agreed in Article 89.1.
Here's one question for you, and also this question, you may also respond to it, and also Jordan, the question I'm going to ask now, because it goes around. If you can briefly deal with this while you're on your feet. One, there's that loopy conundrum we have by operation of Article 13b, which is Article 13b says refer, exercise jurisdiction according to the Rome Statute, something like that. And then AU and Jordan say, well, that's good, but then that comes in 98, so we get into that loop. Is the way to break that loop not this way? This is a question, possibility. How do you reconcile then 27 and 98? Is it possible to look at it in terms of you break that loop by saying when you go to 98, what immunities you recognize in 98 is a remainder of immunities after you've subtracted what is cancelled out in 27. Is that one way to break that loop? So that we don't get into this endless loop of 13B, then 98, we keep going back and forth.
Mr. President, with respect, the very same immunities implicated by Article 27 before the court would be implicated by Article 98(1) before a national jurisdiction. Before the court, we're talking about any immunity available under international law. Article 98(1), we're talking any availability under international law of an immunity, but only in relation to, in effect, the officials of states not party. The very simple fact of the matter is that the statute envisages situations in which the court itself, were the person before it, would be able to exercise jurisdiction, but because of Article 98(1), the person might not get before the court. The statute envisages that situation.
Thank you very much. Mr. Tladley.
Thank you very much, Mr. President. To answer your loop question, I think there are two problems with the loop question. One has been identified by Mr. O'Keefe, and that is that Article 27(2) speaks of all immunities. I think that's clear. So if you're going to do the all immunities minus what's in Article 27, then you have nothing left for Article 98. So that's the first problem.
Are we sure about that?
Excuse me?
Are we sure about when you basically subtracted the immunities in 27, in specific case, it leaves nothing for 98?
Yes, if the idea is there are certain immunities that are being considered for the purposes of Article 27, and to identify what's in Article 27, you subtract those. It's not clear to me how you identify that there are certain immunities that are covered in Article 27 and other immunities are not covered. So what immunities would not be covered under Article 27?
It is a matter of the particular circumstances of a case before the court and what immunity is in question in a given set of circumstances. Once you identify that in a particular case, and then the same case is a case where somebody tries to invoke 98, and then you say, well, we have this thing in this case. Once we remove it from 27, follows that we can't have it in 98.
So again,
isn't that one way of looking at that?
So again, the problem, of course, is, so if we take a particular case, there's an individual, that individual has immunity ratione personae. So you've identified that for that particular case, in those particular circumstances, that's the immunity that he has. If you're going to subtract those, then there's no other immunity that's left with respect to Article 98. So you're really back to the same conundrum. But that's only the first problem. I mean, the second problem is, again, there is nothing, if you apply the rules of interpretation, that would justify that. So that even if it were possible to sort of have this minus, on what would it be based? What legal rule of interpretation would it be based? It's really difficult.
But why not? Isn't it the rule of interpretation well accepted that the treaty must be read as a whole?
Precisely. So the treaty must be read as a whole, takes you back to the rules of interpretation. What do the rules of interpretation say? And I'm just going to look at Article 27(2) and go through, but very briefly, the main elements of treaty interpretation in response to what has been said. So the first point about the plural has already been responded to, so I won't respond to that. And then the question of the national, again, for me, it seems to be a fairly simple point. There is nothing that precludes an accused to raise whatever he wants to raise as a procedural bar. That may be wrong, but he can still raise it. The only thing that that provision seems to be saying to me is to say, well, if you raise it, we're not going to allow it. So there is no significance for this particular issue to the word national. So that's one issue with respect to text. The other issue with respect to text is, just look at that. It says, shall not bar the court exercising its jurisdiction. By the way, counsel for the prosecution said it's effective jurisdiction. It doesn't say effective jurisdiction. It speaks about shall not bar the court from exercising its jurisdiction. There is nothing in there about states, absolutely nothing in there about states. It's only about the accused. So when we speak about the person, presumably we're talking about the accused because I can't see what other person. So it's only about the accused and the court. So you have to read in all manner of things. Now with respect to context, so we will refer to Article 86 as a context, and the fact that Article 86 speaks about in accordance with the provisions of the statute rather than in accordance with the provisions of this part. But of course that only takes you to Article 98, because it is only Article 98 in the context of immunities that is related to cooperation. Part 3 has nothing to do with cooperation. So of course it makes sense in that context if you're thinking about...
When you look at it that way, you agreed a moment ago that a treaty has to be read as a whole.
Mm-hmm.
Can you read a treaty as a whole and still have that blinkered reading of it and said we're only going to look at it in different parts?
The idea is not that you look at it in different parts. That's not what context means. So when we say Article 98 finds itself in Part 9, that's not to say that we're only looking at Part 9. It's to say, but to understand the context of Article 98, you have to look at the provisions surrounding Article 98. I mean, that's what a contextual reading means. Look at the provisions surrounding Article 98 and try to sort of see how the statute as a whole works.
I think
so
it
this
does
idea
more than that, Mr. Platley. If you looked at Article, was that 31?
3.
Is that 3 of the Vienna Convention, the one that explains what
Oh, that's
context?
2.
31.2, right?
Yeah, so that's,
Which one
that's
is
right,
that?
it's 2.
Never
It's
mind.
31.2.
But it tells us that for purposes of context, you look at the preamble to the end, and you look at the in addition to the text, you look at the preamble, you look at annexes, and what else has been done around. So if you can go all the way to the preamble from maybe part 10 of a treaty to look at the preamble to get what the context is, and you can look at annexes.
So I've got it.
How can you move so far but you can look to another part of the same treaty?
No, you can look to the other part, but the idea is to try to establish how the different parts work together. So this idea of identifying that Part 9 is about cooperation tells you that the provisions that are relevant for that are in Part 9. It's not to say that every other part is irrelevant, but to understand Article 98, it's important to look at the text around Article 98. What Article 31.2 simply says is that in addition to the preamble and the annexes, so there's a number of elements that would constitute context. Now, we have also been referred to object and purpose. What's very interesting about object and purpose, particularly if you limit, right, and one, we shouldn't do this, but if you were to limit object and purpose to the fight against impunity, what's very interesting is that the DRC and the South Africa and Jordan decisions all in fact are contrary to this object and purpose, because while they might in fact be contributing to arrest and surrender in the context of this particular case, in all other cases, it's actually against this. So Article 27.2 is given a very narrow interpretation on the DRC reading. So on DRC and the South Africa and Jordan reading, Article 27.2 has a very narrow reading. Article 27.2 only applies to officials of states parties. And I want you to look at this very carefully. That's the whole basis of that decision. So it actually has a very narrow reading. The reading that we are given, that we are proposing, is actually from the perspective of object and purpose, much more satisfactory and favorable to the exercise of the jurisdiction of the court. So in terms of DRC and South Africa, the court cannot even exercise jurisdiction over an official of a non-state party unless it's in these very limited circumstances of a UN Security Council resolution. That's not justified by the text, and it's contrary to the object and purpose, and yet we're not actually attacking that particular interpretation. And I think that's something that ought to be thought of. One more point. We've also been told about effectiveness. Right? So we've been told that this interpretation that's been advanced by Jordan and by the African Union would in fact lead to disabling the court. But that's just simply not the case. there have been over 40 indictments, there have been over 40 individuals indicted. Over 40 individuals indicted. And this interpretation does not at all contribute to the court not being able to exercise its jurisdiction. It applies in very limited circumstances. And this is one of those limited circumstances.
Is it enough to indict?
Excuse me?
Is it enough to indict?
No. So my point is not that there have been indictments. That's not my point. My point is that to the extent to which this particular interpretation that we're advancing might limit the ability of the court to exercise its jurisdiction is really only visible in one case, only in this particular instance. In all other particular instances, this interpretation has no effect whatsoever on the interpretation of the court's jurisdiction. I thank you.
Thank you very much. Mr. Murphy.
Thank you, Mr. President. We've covered a few different issues over the past half hour or so. I thought I would just touch on a few of them. You asked the question about official capacity versus immunity in Article 27, Para 1 and 2, and Professor O'Keefe responded to an extent on that. I think his interpretation is correct. If it's helpful, the most recent International Law Commission discussion of that very issue appears in the 2017 annual report of the Commission in Chapter 7 with respect to the draft articles on crimes against humanity. And there's a draft Article 6 that has commentary to it where that distinction between essentially 27.1 and 27.2 is discussed in some depth. Professor O'Keefe also mentioned the Article 91.1 versus 98 scenario. That may well be right, and we would add to that the Article 86 general obligation to cooperate is very much expressed as in accordance with the statute, so you do have to read the different provisions. As I understand it, the prosecution theory is that 27.2 strips away immunities of officials of state parties such that when you get to Article 98, the reason why it's there, the residual value of it, is that it maintains the immunities for non-state parties. And that's why we have it, if I understand their theory correctly. One problem with the theory, other than this idea that I think Mr. Talati was capturing, that it's a very different part of the statute, and it looks like Part 9 is addressing everything holistically, so why go to 27? But separate from that, when you go to Article 98, Paragraph 1 does not refer to non-state parties. Paragraph 2 does not refer to non-state parties. As I indicated this morning, in this very part, we do have references to states that are state parties, states that are not a state party. I pointed to Article 90, paragraphs 2 and 4. And so right off the bat, the ordinary language here, the ordinary meaning of Article 98 doesn't really take you to a place that I think the prosecution feels you have to go to make the Article 27.2 theory work. And the last point I would add on this is there's been considerable discussion about whether Article 98, paragraph 2, applies with respect to the League treaties. We would submit that it does, that a sending state is fully to be interpreted as a situation where a state like Sudan sends its officials at whatever level to another country. We don't think there's anything unusual about that. But what is somewhat striking in the prosecution's at least written pleadings is that they feel very compelled to argue that paragraph 2 doesn't apply to the League treaties because of this sending state issue, but presumably the Article 27, paragraph 2 theory should also knock down any immunities operating under those Article 98, paragraph 2 treaties. In other words, even a status of forces agreement between, say, the United Kingdom and Afghanistan, if there's any provisions in there on immunities, those presumably are struck down by this Article 27 theory. We have doubts about that as well. We'd welcome an explanation if they think it does have that effect, because it feels like they're ignoring that and trying to instead very hard say that the League treaties don't fit paragraph 2 for some other reason. Our view is that the Arab League treaties fit both paragraphs 1 and 2. Paragraph 1 is focusing on immunities under international law generally, and the treaties speak to that. Paragraph 2 talks about a situation of where you have an obligation not to surrender owed to another state under an agreement, and we submit that the Arab League treaties certainly fit that as well. If we're correct that they would not apply their powerful Article 27.2 theory to Article 98, paragraph 2, then it's a reason why the theory is probably wrong. Because if it is to apply, it would have to apply to both parts of Article 98.
Yes, I will return to Professor Latanzi and the prosecution, but to Mr. Murphy now. You've made this submission earlier, and you've made it again, about certain language that have been used in certain provisions which we're not seeing in 98, being a clue to what it's supposed to do. What about the consideration? What about this consideration? There are provisions in the Rome Statute that would say, without prejudice to what is said in the other provision. This is what we're saying here. There's a series of provisions worded in that way. If the idea is to exclude 27 from 98, couldn't that kind of formulation have been used in 98? One, saying without prejudice to 27, 2. This is what we're saying in 98.
Well, if I understand the question, Mr. President, could they have written Article 98 or indeed other parts of Part 9 to in some fashion say either Article 27 has an effect or does not have an effect? Yes, they could have written it that way, and maybe in hindsight, here we are 20 years later, the issue is before us and it would have been helpful to know one way or the other. But I do think when you look at Part 9 as a whole, you look at the fact that it's addressing the issue of cooperation of states with the court. It's expressly addressing the issue of immunities. There's no issue there. It's expressly addressing foreign criminal jurisdiction, third state jurisdiction. It's a package that to us seems quite apparent from the ordinary meaning of the text, the context within which it's operating. And it's quite unusual to go out and reach for a completely different part of the statute and a different provision that's really speaking just about this court's jurisdiction as a means of somehow changing, in our view at least, changing the meaning of carefully drafted provisions in Part 9. There's nothing sloppy about this. States were very focused on it and very conscious of what it was they were trying to do, and we think what they were not trying to do.
About if the head of state, the visiting head of state, the visit is from a head of state that's under indictment for the ICC. Whose state is a state party to the Rome Statute? Goes to state B, also a member state of the Rome Statute. In light of your theory that 98 talks about a third state, including also member states of the Rome Statute, are you saying that in that kind of scenario, there is immunity for that head of state?
Jordan's position is that Article 98 would apply by its terms to that. That would include, presumably, that the sending state, if you will, may have a Rome Statute obligation to cooperate with the court, which would include then the waiver, but that the court should then be dealing with the Rome Statute party whose official is at issue get that waiver, so that then the host state, if you will, would be able to surrender the person to the court.
Thank you very much. Professor Lutanzi.
Merci, Monsieur le Président. Je pense que la discussion est en train un peu de compliquer les choses. Je les vois de façon un peu plus simple, peut-être aussi parce que j'ai participé aux travaux préparatoires du statut de Rome comme conseiller juridique de la délégation italienne. Et donc, étant donné qu'en application des critères principaux de la Convention de Vienne, d'interprétation de la Convention de Vienne, on n'est pas d'accord, on devrait se pencher un peu sur les critères subsidiaires, tenir compte des travaux préparatoires. Et je me rappelle bien que il y a un rapport, naturellement, entre 27 et l'article 27 et le 98, et que le 98 est venu de deux préoccupations. Des États qui ne voulaient pas que leurs officiers puissent arriver devant la Cour pénale internationale, et des États qui se préoccupaient aussi de la possibilité de la Cour pénale internationale de toucher, pour des questions de réparation des victimes, de toucher aux biens de l'État. Et donc, cela a porté à se mettre d'accord pour l'article 98 et parler d'État tiers plutôt qu'État non parti au statut de Rome. Alors, le problème qui se pose ici, c'est de voir, étant donné que le 98, 1, et après aussi 2, représente effectivement une exception au 27, mais quand est-ce que cette exception fonctionne? Alors, pour la Jordanie, c'est clair, et que ça fonctionne même dans les rapports entre les États partis et les États pour lesquels il y a une juridiction selon le critère national à un titre différent que la ratification de l'État, c'est-à-dire la décision du Conseil de sécurité et l'acceptation ad hoc de la compétence. Donc, le seul problème que nous avons devant nous ici aujourd'hui, non, ce n'est pas le seul, mais un problème fondamental est de voir cette exception de l'article 98 à ce moment-ci, quand elle fonctionne par rapport au 27. Elle ne fonctionne jamais, ni, c'est l'interprétation que je me permets de présenter aussi sur la base de mon expérience aux travaux préparatoires, jamais dans les rapports entre, parce qu'il ne peut pas y avoir un conflit d'obligation entre les États partis au statut de Rome. Il ne peut pas y avoir un conflit d'obligation, parce qu'il y a l'article 27 toujours, entre les États partis au statut de Rome et les États qui ont accepté une juridiction ad hoc et pour les situations renvoyées pour les États qui sont impliqués dans une situation renvoyée par le Conseil de sécurité. Et donc, pardonnez-moi, mais je pense que la discussion c'est un peu compliqué de façon un peu inutile. Pardon.
Mr. Kress first.
Your Honor, I have listened with great interest to the intervention by Mr. O'Keefe, and with very great respect, I have to say that I disagree with essentially all key points he made about the relationship between Article 27 and 98. I will not explain again why, because it's all in the record and you have heard it. What I want to point you at is one flaw, one inconsistency in his argument which has become apparent to me today while listening. We have heard Mr. O'Keefe yesterday making a passionate pleading for a waiver of immunities requiring something explicit. That was a very fundamental point. In his argument today, it was almost a key point to assume that immunities can be waived implicitly. Because he says, again passionately, as if all other positions would be almost nonsense, that Article 27.2 is not dealing with the cooperation context, has no relevance whatsoever for the cooperation context. A consequence of this argument is that for the purposes of cooperation, these immunities should still be there. Now he is saying they still do not prevent them working within the context, within the relationship between two state parties. He has said that. So how has out of a sudden the immunity disappeared? He says, if I have understood correctly, because it is obvious from what state parties wanted, from what is clear from the travaux préparatoires. This is no explicit waiver. It's the opposite. And I refrain, and I do this with reservation and to save time, to make the point of my memories of the drafting history. I have been one of the drafters of Part 9. But I don't want to make this argument because it's whatever is not in the travaux préparatoires doesn't count. My stories doesn't count. But that's an obvious inconsistency. It seems to me a kind of cherry picking. One day we say it must be explicit, the most explicit we can imagine, and today we are very generous in that respect. Thank you.
Thank you. Now we'll hear from the OTP. Mr. O'Keefe is also on the speaking list. We have to start thinking about wrapping it up. But Mr. Cross.
Thank you, Your Honours. And I have to say, I rise with some trepidation because it's a fast-moving conversation, and where I thought I was starting some 25 minutes ago, we've now covered a lot of territory. First, I'd start by saying I'm very grateful for the observations of Professor Lattanzi and Professor Kress. It would seem, at least to me, that Mr. O'Keefe's argument that in fact we should be starting from 89.1 and not from 27, but nonetheless to unlock the significance of 89.1, Mr. O'Keefe takes us to 98.1 in order to find out actually how we deal with this problem of immunities. And we would agree absolutely, I think, that 98.1 and what role that plays in the statute is crucial. We would say 98.1 in fact points you towards 27, but we'd agree that discerning what the drafters meant by 98.1 is very important. We would also agree that, given the debate we're having, supplementary means of interpretation, reference to the travaux, we would also urge that consideration. Just very quickly on, I think, Mr. Tladi's point, that if you take the view that we would submit that in fact 27 is relevant to disapply certain kinds of immunities for states which are, for one reason or another, bound to the obligations of the statute, that leaves little role for 98.1. We would simply say we disagree with that. First off, 98.1 in its own terms is clear in not only applying to requests for arrest and surrender, but also other kinds of assistance under the Rome Statute. In its own terms, 98.1 specifically refers to property, and there obviously there are obvious concerns. The court might seek property from diplomatic premises under Article 93, and then that runs into immunity problems. There are also other sorts of requests that the court might well be making under Article 93, which would nonetheless raise questions of immunity vis-a-vis individual persons, potentially. There's also the question, which remains and with which we agree, that 98.1 always has application for immunities which are owed to persons of states which are not in some ways subject to obligations of the statute. So states which are not states parties, are not 12.3 states, and are not subject to a UN Security Council resolution, which in some way brings them into the orbit of the court. So no matter which way we look at 98.1, we see 98.1 as an important procedural safeguard in the statute, and indeed one which, as we've said earlier this week, always also finds application even in the very circumstances of this case where the court has to consider the 98.1 question, even for states which are subject to the obligation, even if the answer then is a simple one, we say because of 27.2. In terms of third states, therefore, Mr. Murphy's mentioned a couple of times that there may have been some ambiguity in our initial written submissions about whether or not we were trying to take some complicated point about which states fell within 98.1 and which do not. I can just refer your honours to filing 377, paragraph 27, where we took that point from Jordan and did seek to clarify our position. The short answer is, third states, we agree. That's all states other than the requested state. And so therefore it might be states parties, it might be non-states parties. Who we're talking about depends on the facts. In terms of 98.2, and I'll only go into this, I think, with your honour's permission, a little way for the time being. First off, yes, it is true that we do not think 98.2 is applicable to the 1953 Convention, or indeed the 1945, I think, Pact in this case. And that is primarily a concern for us out of, if you like, a sort of legal tidiness of mind. We see those treaties, because they relate to privileges and immunities, finding a natural home in 98.1, just because that is their subject matter and that's the notion which is in 98.1. So for that reason, as Professor Kress said earlier, we think it would be superfluous to put the same subject matter of treaty in two different provisions of the statute, which both lead you to essentially the same question. So the reason why we took a somewhat hard line on saying, no, we don't see those treaties in 98.2, it's because we see them as being 98.1, and we're then a little puzzled if it falls under both. The further question which Mr. Murphy has now raised, which is, well, what does 27.2 mean in the context of 98.2? Well, of course, we didn't take that point in this appeal because we don't have a 98.2 agreement at stake here, in our view. And I have to say, for my own part, it's a really interesting question, and I hadn't developed my own thinking a great deal until Mr. Murphy mentioned it. I do have an initial instinctive position, but in the interests of being a good member of the office, with your honour's permission, I would prefer to share that with you tomorrow once I've had a chance to talk to my colleagues, rather than taking a position which the office may later wish have cause to regret, put it that way.
I think that seems like a very wise
Then I'm very
approach.
grateful, and we'll come back to that in the morning then, your honours. Thank you.
Now we know that Mr. O'Keefe wants the floor. Mr. O'Keefe, let's do it quickly.
Mr. President, I'll try I'll try to be brief.
Very brief.
I am a little saddened that I'm thought to be saying that only my point of view is the only possible one. Quite the opposite. Quite the opposite. My theory as to Article 89 has a weakness. Waiver has to be explicit. It goes to prove what I'm always told by my partner, by my ex-wife. I'm too nice. I'm too kind. I was trying to find some halfway house. If my halfway house falls down, the answer is not Article 27.2. The answer is precisely what was given to us by Counsel for Jordan. We must rely on explicit waiver, and that explicit waiver in relation to states parties would be requested by the court. Now, they may not give it, in which case we're stuck, but they'd be requested by the court. Why do I say that? It's a simple matter of treaty interpretation, and I'll be brief. We've been told that we have to look at context. The International Court of Justice speaks of not only the other provisions, but the overall structure of the treaty. We've heard about the overall structure of the treaty. Part 9 is about cooperation and assistance. Part 3 is, according to this point of view, all about the court. We've heard about the provisions of Part 9. I want to just talk, just very briefly, read a few other provisions from Part 3 to show that Part 3 is all about the court. Article 25.1, the court shall have jurisdiction over natural persons pursuant to this statute. Article 26, these are all in Part 3, the court shall have no jurisdiction over any person who was under the age of 18 at the time of the alleged commission of the crime. Now, they both say the court. They clearly have no application at the national level, because in many national criminal justice systems, you can be under 18 at the time. In some criminal justice systems, moral persons, corporate entities, can be held responsible. Article 22.1, a person shall not be criminally responsible under this statute. The only place you're criminally responsible under the statute is in the court. At the national level, you're criminally responsible under national law, perhaps giving effect to the statute, but under national law. Article 24.1, the person shall be criminally responsible under this statute for conduct prior to the entry into force of this statute. Now, we know full well that you can be criminally responsible for a war crime, genocide, crime against humanity in a national jurisdiction prior to the entry into force of the statute. 24.1 is about being before the court. 22.1 is about being before the court. 25.1, the court shall have no jurisdiction over. All of Part 3 is about being before the court. And let me emphasize, Mr. President, honourable members of the court, the Rome Statute does not oblige states to enact into law the crimes within the jurisdiction of the court. It does not oblige states to prosecute under national law the crimes within the jurisdiction of the court. They may, and they sometimes do. But let's take Article 25.1, individual criminal responsibility, aiding and abetting, etc. The vast majority of them, when they do not give effect to Article 25 to all that sort of thing. They use their domestic principles of criminal liability. What I'm trying to tell you is that not only is Part 9 all about cooperation, but Part 3, reading the context, all the other provisions of Part 3 are about the court. If that's the case, why, oh why, would a single provision, Article 27.2, have application beyond that context? And not only that, why would it have application in a context which is already covered by another part of the statute? In the International Court of Justice, my final point, in the application of the Interim Accord of 13 September 1995, the former Yugoslav Republic of Macedonia, soon to be renamed, and Greece, at paragraph 97, the court took into account what part of the statute, of the accord something was in, and said, this part of the accord is about this part of the accord is about that. And the court said that the overall structure of the treaty must be taken into account. So yes, we must read it as a whole, Mr. President. And what the whole of the Rome Statute tells us is that Part 9 is where you talk about arresting and surrendering people to the court. Part 3 is where you talk about what happens in the court. It so happens to be that the obligation of cooperation and arrest and the exception therefrom in relation to states in relation to whom you owe obligations, Article 98.1 is in Part 9, and Article 27.2 is in Part 3. Now, unless it's the only provision of Part 3 that extends beyond the court, then it applies only to proceedings before the court.
Thank you very much. I think we've, Mr. Robinson, because we've not heard from you in a long time.
And actually, it's not to respond on that. I have
One second, please,
Sure.
1 second. Yes, please, Mr. Robinson, proceed.
Mr. President, it's just a procedural comment, and I'm not even sure if this is appropriate. You may have given the scholars too much time for tomorrow, and I think there might be some support for that. But your goal was to finish by lunchtime, and as I'm doing the math, if there are 4 amicus curiae, it might be prudent to restrict us to 20 minutes, just as food for thought. Yes, enough professors.
I see Mr. Cross shaking his head, saying all his views, and we very much appreciate it. We'll return tomorrow at 9:30, and when we'll get the roundup remark from everyone. So we're adjourned for the day. Thank you.
All rise.